Welcome to Details in Divorce, where we break down the legal, financial, and emotional aspects of divorce to help you make informed decisions. I'm your host, Paul Riley, and each episode we dive into key issues that impact individuals who are navigating separation and divorce. So, whether you're concerned about asset division, protecting your business, or dealing with foreign property disputes, we are here to provide clear and practical insights. This week, we're exploring a story that plays out in the boardrooms and barns across Ontario. What happens when generational agricultural wealth meets marital breakdown? Imagine this. I'm sitting across from a client whose family has built a $40 million agricultural empire over 4 generations. Dairy operations, cash crops, real estate holdings, supply management quotas worth millions. But after 22 years of marriage, his wife wanted out, and she wanted half. The question that would keep him awake is not just about money, it's about legacy. How do you divide an empire that took a century to build? How do you protect what your great-grandfather started when the Family Law Act says your spouse is entitled to equalization? This isn't just about farming. It's about what happens when Ontario's family law collides with multi-generational wealth, complex corporate structures, and assets that can't simply be liquefied and split. Here's what makes agricultural divorces uniquely dangerous for high net worth families. The assets are both massive and the assets are also illiquid. Consider the recent Iredale v. Dougal case. The wife inherited shares in a farming corporation from her parents, shares controlling nearly 100 acres of prime agricultural land plus the operating business. The home farm consisted of approximately 99 acres with a house, detached garage, and other farm buildings. An appraisal set the value of the home farm at $1.3 million, with a breakdown of the value of the lands and buildings. The husband claimed that the home and several acres around it comprised the matrimonial home, while the wife asserted that only the home, detached garage, and 1 acre should be considered matrimonial. The question wasn't just who gets what, it was whether the entire operation would even survive the division. The court had to dissect the property with surgical precision. Which part of this 99-acre holding was in fact the matrimonial home that couldn't be excluded from division, even though it came as an inheritance? The court also considered how to value and apportion the matrimonial home when the property is used for both residential and farming purposes. The difference between 2 acres and 20 acres could mean hundreds of thousands of dollars in the equalization calculation. Section 4.2 of the Family Law Act excludes from a party's net family property all property other than the matrimonial home received by gift or inheritance after the date of marriage. Section 18 of the Family Law Act deals with the matrimonial home and states that every property in which a person has an interest and that was at the time of separation ordinarily occupied by the person and his or her spouse as their family residence is in fact the matrimonial home. Section 18.3 of the Family Law Act provides that if property that includes a matrimonial home is normally used for a purpose other than residential, the matrimonial home is only the part of the property that may reasonably be regarded as necessary to the use and enjoyment of the residence. The court fixed the amount of land connected to the use and enjoyment of the residence at 2 acres for the purpose of determining the matrimonial home in this case. The rest deemed agricultural business assets subject to different rules entirely. For high net worth families, understanding this distinction isn't academic. It's the difference between preserving generational wealth and watching it get carved up by the family court orders. This brings us to the most critical protection in Ontario family law for agricultural wealth and why most wealthy families don't fully understand it until it's way too late. Section 11 of the Family Law Act provides that courts cannot order the sale of operating farms or businesses unless there's absolutely no alternative. It sounds protective, but as the Ernest v. McDonald case demonstrates, this protection has limits that can blindside wealthy families as well. The couple in this case owned 5 farm properties with significant value. The husband assumed Section 11 meant he could keep everything operational and intact, but this was wrong. The court performed a forensic analysis on each property. The home farm with its essential equipment, grain storage, seed cleaning plant that was untouchable. But the other properties, 4 parcels of what the court saw as non-essential land, were ordered sold immediately to fund the equalization payment. For families with complex agricultural holdings, this case is a warning. Courts will sacrifice parts of your operation to fund equalization if those parts aren't deemed essential to the core business. Your entire portfolio isn't protected just because it's all agricultural. The most dangerous scenario for wealthy agricultural families isn't divorce itself, it's the informal succession planning that sets up catastrophic failures, sometimes decades later. In Metsky v. Metsky, this case shows exactly how this plays out. Martin and Roseanne had built a successful dairy operation. Their son Tim and his wife Amanda left their careers to take over the farm, working alongside the parents for years with the understanding they would eventually purchase it at fair market value. Sounds reasonable, but the Court of Appeal had a different view. When the relationship soured, the parents sold to others instead. Tim and Amanda then sued for $1.3 million, claiming proprietary estoppel, essentially arguing that the parents had made promises they'd relied on to their own financial detriment. The court's response was brutal. An agreement to agree or an understanding that the parties would negotiate terms for succession does not amount to an assurance that can properly ground a finding of proprietary estoppel. Translation, your handshake deals and family understandings are worth nothing when millions of dollars are at stake. For families engaging in succession planning, this case is a masterclass in how good intentions can lead to legal disasters. The matrimonial home rules present a particular trap for agriculture wealth families because the stakes are so much higher than typical suburban divorces. In Martin v. Sansome, we see a farm that had been in the husband's family for over 180 years. Not just any farm, this was a substantial operation with both residential and significant agricultural components. The question of what constitutes the matrimonial home wasn't academic. If the entire property qualified as matrimonial home, none of it could be excluded from equalization, even portions purchased with inheritances or gifts. We're talking about hundreds of thousands of dollars in potential exposure here. The court found that only 18% of the total property value constituted the matrimonial home. The rest was agricultural business property subject to different exclusion rules. For wealthy families, this precision matters enormously. The difference between having your entire agricultural holding treated as a matrimonial home versus having most of it classified as business property can determine whether generational wealth survives the divorce or gets equalized away. Here's what sophisticated agricultural families need to understand about protecting generational wealth through family breakdown. 1. Documentation isn't just helpful, it's essential. When millions are at stake, courts won't accept family stories about gifts, informal arrangements, or succession understandings. Every significant transfer, every major decision, every family agreement needs formal documentation with proper legal structure. 2, understand the matrimonial home trap. Just because your agricultural operation includes your family residence doesn't mean the entire operation gets matrimonial home protection. Plan your residential footprint carefully and document the business versus residential use of all property. 3, Section 11 protection for operating farms has limits. Courts will protect essential operational assets, but they'll sacrifice non-essential properties to fund equalization. So structure your holdings accordingly. 4, succession planning requires more legal structure, formal structure, not family conversations. The courts have made clear that informal understandings, even spanning decades of reliance, won't be enforced when family relationships breakdown. And finally, remember that agricultural quotas are often your most valuable assets, but they're also the most complex to value and divide. These aren't just regulatory permissions, they're sophisticated financial instruments that require expert handling in divorce proceedings. The reality for wealthy agricultural families is that divorce doesn't just threaten individual wealth, it threatens generational legacy. We're not talking about dividing assets, we're talking about the potential dismantling of enterprises that took generations to build. The courts try to balance fairness with operational reality, but their primary obligation is to the Family Law Act's equalization requirements, not to preserving your family's agricultural empire. The families that survive these challenges intact are the ones who plan proactively with sophisticated legal structures, proper documentation, and a clear understanding of how family law intersects with agricultural wealth. The families that don't, they become a cautionary tale about how even the most successful agricultural operations can be vulnerable when generational wealth meets marital breakdown. That's our look into when divorce meets generational agricultural wealth. If this resonates with your situation or your planning concerns, the time to act is before you need these protections and not after. Well, that's it for this episode of Details in Divorce. We hope you found today's discussion insightful and valuable as you navigate your own divorce journey. Remember, every situation is unique, and getting the right information is key to making the best decisions for your future. If you have any questions or need guidance, the Riley Firm is here to help. Be sure to subscribe so you don't miss our upcoming episodes where we continue to explore the critical issues that matter most during divorce. I'll see you next time.